Hello. Mediation is a good alternative to litigation. And depending on who the mediator is, it could be free. It could be very, very expensive. Sometimes 400 to $800 an hour for a mediator. Again, that would be for a very complicated divorce or a commercial dispute like construction or something like that. So many times the courts will order you into mediation. Each courthouse, each county or city would have their own arrangements, their own procedures. Many times one of the parties could ask for mediation. There was one case I even asked that the court have a settlement conference with a judge overseeing it, and that worked out very well. It was not a courtroom experience. We were able to just talk. The lawyers talked, the clients talked on each side. The judge was very sympathetic and understanding as to what each party's position was. That was not a divorce case. It was a very difficult, emotional, uh, another something other than family law, but still equally combative and very, very emotional for everyone involved. But we resolved it with the help of the judge. And so that was simply a local rule that was only, as far as I know, only in that one county, that would allow for that. And even the judge said that it's normally to force for a car accident or a personal injury case, to force the insurance company to talk to the plaintiff, that there's a the court can bring the insurance company and the and the defendant and the defendant's lawyer, of course, everyone, into court. I mean, physically go into the court building and sit there and, answer questions and present their position, forcing them to, get involved in the case. But there was nothing that said it couldn't be used for my client's particular situation. So there is, the courts many times will appoint the mediator. The mediator may have different names. Fairfax County, Virginia. So we'll appoint a neutral case evaluator. They have that in their rules. Many times when there's a discovery dispute, so a small dispute within the big case as to turning over documents, as to answering questions, the court could appoint someone just for that. The other side doesn't turn over any bank statements. Say it's a divorce that involves property. Well, why not? Well, because the person doesn't feel like doing it, in which case they should get uh, penalized by the court, or maybe they literally don't have bank statements. Maybe they use everything in an American Express card or some kind of hybrid brokerage account, banking procedures inside your brokerage account, and then they've turned that over. So something that may look like suspicious, could be perfectly easy to explain away. Many times they don't have the documents, in which case the try to work out a way to get the documents, whether the person had to go to the bank to get the bank statements access. You could have a written permission, please copy off my trust documents and give them to my wife's divorce attorney, something like that. Those avenues for mediation would be available within each court into their local procedures or local rules. So that should be something you'd want to look for. And again, if it can be resolved without a trial, you're going to save just enormous amounts of money. If you can't afford a lawyer, which many people can't, there are free legal services sometimes available in some situations. There's also the legal aid, the legal services. The term pro bono is usually the way that the overall is described. Pro bono is Latin, meaning for free. And many times, lawyers will actually volunteer their services, regular practicing lawyers. Depending on the jurisdiction, there may be lawyers who that's their full-time job is to represent hundreds of people or hundreds of cases. They do it at no charge to the client. And of course, they have a regular salary paid for by this independent organization, usually funded by government funds or contributions or something like that. So, and those organizations always have, seemingly always have very good websites. So if you want to, get the lay of the land, understand how your case might work or what to expect next, going to those websites, they'll give you a short but a very accurate description of what you're going to expect. If you do have a family law case, and again, that could be a divorce, but even if you're not married, if you're fighting over custody and visitation, it's going to cost you a lot of money. The most expensive is a custody battle. Again, whether you're married or whether you're not married, there would be a family courts in some jurisdictions. In Virginia, it's called the Juvenile and Domestic Relations Court. So if you're not married or if you just want a narrowed issue like custody or child support, you might consider going to that court. Trials usually happen more quickly. The trials are shorter, so half a day instead of 3 days. So, and you can always in the Virginia JDR, Juvenile Domestic Relations Court, you can always appeal it to the circuit court and have a brand new trial. The typical situation in any trial, whether it's family law or something else, is gathering the information. And that's a process called discovery, where one side will send over to the other uh, a list of questions that have to be answered under oath. That's called interrogatories, which is just Latin that means questions. And then number two is requests for production of documents, which the request for production of documents. So that gathering that information, answering those questions, making sure you include everything there, list all your bank accounts, list all your credit cards, the dates, the numbers, the how much you owe so the way that my office works is, you know, we start gathering that information at the beginning. We know it's coming even before we file the case in court. We know that the other side is going to demand bank statements, tax returns, pay stubs, school records, medical records. We know the property information that we have to gather, title search, the deed, the mortgages, the bills, um, the car loans, the car titles, the retirement plan information. So we just start gathering that. So the lawyer or my office, the lawyer should sit down with you at the start of the case and say, here's what you need to give us sooner rather than later. Don't wait for discovery deadline begins with 21 days or 30 days. Um, that those days pass very quickly. So just be aware, if you have to go to the bank and get copies of your bank statements because you throw away all your bank statements every month, do that. Where are your tax returns? How can you get your tax returns? Requesting them from the IRS will take 6 to 8 months. So that's not what you want to do. So just be aware of that. Again, if you want to save a whole lot of money, know that you have to do that. The lawyer should tell you what you have to provide. Health insurance for the children, daycare for the children. If the children have special needs, you're going to need to document that, and not only the illness or the situation or the handicap that the child has, but also the expenses that arise from that particular, whether you're spending it on a regular basis, or whether you might have to spend it in the future. So just be aware that all of those items, a lot of times these questions are standard, and it's pretty much the same questions, or they call them model interrogatories or model requests for production of documents. So I know what they're going to send, they know what I'm going to send, and it pretty much would cover every situation in a contested family law matter. So your lawyer should give you those ahead of time. Just here's what you're going to have. Do you have any businesses? If you do have a business, here's what you're going to need to provide. Do you have a vacation home? Do you have a another child from another relationship? So know that those requests are coming. Know that that's something you're going to have to provide and turn over. So the way that my office works, and probably most offices, is you're assigned a paralegal. Now the paralegal is billing by the hour. I bill a lot more. The paralegal bills less, a hefty amount by the hour. And so if the paralegal has to gather your documents, the paralegal is going to bill, and you're going to have to pay the law firm for that time. If you can gather your documents, then you save that amount of money. The most expensive part is going to be the trial, where the lawyer has to be in court, you know, and so that is going to be, but that's the end of your case. That's way down the road. 90% of divorce cases will settle, so more than likely your case will settle. Um, my job is to get you into that perfect situation where you are in the strongest position for defense, and you're in the strongest position for offense. And the other side realizes that, and you can put together a settlement and resolve it without going for a trial. But then that's the most expensive, is the trial. The second most expensive is what I just described, which is discovery, or gathering all of this information. And don't forget, you have to give it to them, and they have to give it to us. So when we receive it, we have to go through it and look at it and say, "Hey, what's missing?" So my office will send it all to you, and you can go through it, and you can say, "Hey, wait a minute. Here's this bank account, but there's no food expenses. So how does the person eat?" Obviously, they haven't given us the big picture. Well, maybe the person uses their credit card to buy their food and the bank account to pay the credit card. So we'd want to look at the bank statement, then we want to look at the credit card. But if we can't find food expenses, for example, then we know that the person is withholding. There's something more out there, and we can go into court, file what's called a motion to compel. Again, that is expensive because the lawyer has to do that. Only the lawyer can appear in the courtroom. And then hopefully in that narrow situation with a motion to compel, we can get the other side to pay attorney's fees as a punishment. Those documents have to be presented in a certain way. Each law firm is going to have their own procedures. You should ask the law firm how that works. There's a lot of different procedures to do that. They all work fine, but just be aware that you can deliver those documents in a certain way. I mean, chronological order, for Pete's sake, that please. You shouldn't have to pay someone to sort your documents out January, February, March, April, May. Just do that yourself. The same thing from the other side. If the other side drops off a giant box of miscellaneous papers and unopened envelopes, and they all smell like cigarettes, my practice is I would like you to come in, and you could sort through those documents and tell me what's there. And so be aware there's a lot of ways that you can save yourself a huge amount of money. Of course, it does mean you have to do the work yourself. If you're working a full-time job, if it's Monday through Friday, 9 to 5, that might not be even practical. Talk it over with your attorney. There are ways that you can minimize it. The benefits of going with a settlement, it's not only saving a lot of money, but it's also preventing the destruction of the relationship. If you can work something out and mediate it, you still hate each other, but or you still resent each other, or the unforgiven slights and insults and broken trust is still there, but at least you're not displaying it all in a courtroom. And do you really want your children to testify against the other side? You know, Many clients do. And if you want that, then it's going to cost you a lot of money to get that litigation in court. You might be almost there with a negotiated settlement, and you will have a lot more money. And I tell my clients, you could save the money and spend it on the kids. Take the kids to Disneyland or something like that instead of paying me. But again, I work for you. I do what the client tells me to do. As far as communication with your lawyer, yes. Um, this is a stressful situation. Don't just disappear. Uh, a lot of clients will go, I don't know, they just go missing in action, or they have the reaction of a turtle. They can just ignore the problem and it'll go away. Well, it doesn't. And like I said, if you don't respond to discovery, if you don't talk to your lawyer, tell your lawyer what you want, the background of your case, you're going to end up with probably a motion to compel and paying the attorney's fees for the other side. So, you know, the lawyer should have a timetable of many meetings with you. The lawyer should be sending you regular communication, probably not daily, but certainly when something important happens, or maybe just once a week. We're still here, we're still representing you, and we're just waiting for the other side, or we've ordered records from the school, we're waiting for that, something like that. Oh, that's another thing actually that's very important, saves a huge amount of money, is you can, as a parent, um, or as a joint owner of a bank account, you have the rights to that information. So you can go to the school and get all the child's records, the doctor, the daycare provider. If you're on a joint bank account, then obviously get all that. A joint tax return. You can contact the IRS and get a summary of your tax return. To actually get the full tax return from the IRS, it's gonna be expensive, and it's gonna take a long time, and your case will probably be over. You can go to, your health insurance, and depending on you may be able to get information on your children's health insurance. Anything like that you can gather on your own and just hand to your lawyer is going to save you a lot of money, and it's gonna, make the lawyer happy too. Make your paralegal happy, as to having this delivered to them, easily and efficiently. So there should be a method of communication with your lawyer. The way that my office operates is you'll be assigned a paralegal, and that will be your first point of contact. And the paralegal's responsible for moving your case forward, keeping up with court deadlines. I assume there's discovery going on, getting the information from you, but also, we put together a deficiencies. So what did the other side not give us in discovery? So did we get all the bank statements? Did we get all the credit cards? We look at the bank statements line by line. Is there money flowing in and out of the bank account? Well, if there is, where is it going? Where is it coming from? If there are deposits being made into the bank account, regular deposits of cash, where is the cash coming from? Um, so that's the kind of thing that you can look at, the client can look at and point that out to their lawyer. Like, hey, there was a $5,000 withdrawal made, right before the divorce was filed. Where did that money go? That's the kind of thing. Or why is there this, expense, 200 miles away every other weekend? And, you investigate it and, oh, well, that's a motel that every other weekend, that's probably adultery. I mean, that's your lawyer would want to look into, that there's no reason for your spouse to be going to that motel every other weekend. There's no business reason. There's no family reason. So that's the kind of thing that jumps out at you after you've looked through the bank statements of a few hundred clients. So that's what you want to see, and you can do that. Point out something that's odd, weird, suspicious. The person might be spending too much money on food. They'll have $2,000 a month food expense. Really, they might be spending that, but obviously that's just crazy. So we would want to point that out to the court that, all the different places where the person is getting takeout, restaurant meals, home delivery through a delivery service or whatever, and their food expenses, is abnormally high. As far as how you pay your lawyer, so the most common way is an hourly rate. That's the way I bill. There are some this is in the family law area. So the most common method is the hourly rate. You hire the lawyer, and the lawyer or the paralegal or the clerk will do the work, keep track of their time, record it, and then you get a bill that shows, which person did what work. So you have the date, the person who's doing the billing, the hourly rate for that person. So again, as the attorney, my rate is the highest, and then you have the paralegal, and then we have an office clerks at a lower rate. So you could see potentially, three different people working on your case. Um, the the main person would be the paralegal, and then there'd be a description of what was done, and then how much the fee is. Just the time spent multiplied by the hourly rate, and then um, that would be the amount that's owed for that service, whether it's a phone call, whether it's preparing discovery responses, whether it's, getting on the phone with a credit card company trying to get credit card statements, talking to the clerk at the courthouse, that kind of thing. There are some lawyers in the family law situation who do flat fee work. That is generally a very narrow legal service. So, for example, uncontested divorces. There are a number of lawyers out there, and they advertise all over the place. And they'll do, you know, divorce, uncontested divorce, and then a price. And because it's an uncontested divorce, so that means that you have to agree to it, your spouse has to agree to it. You just want to get divorced. And generally there's no kids, there's no property, and the flat fee is, perfectly acceptable in that situation. But human nature being as it is, most of the time, that's not the situation. There are children, there is disagreements over that. There is property that has to be divided up. Do you keep the house? Do you sell the house? How do you divide the pension plan? It's 50-50. Is it something different? Um, so that's where you'd want to hire a lawyer like me to do more work, really more work than an uncontested divorce. And that work, I bill it by the hour. Um, I have heard of some lawyers out there who will do a flat fee for a complicated divorce, $50,000 up front, something like that. And then the lawyer just does what the lawyer has to do. And again, that might be, depending on what the lawyer's doing, that might be a good arrangement for everyone, but that's rare also. Again, most lawyers in a family law situation will charge an hourly rate, and then there are lawyers who, I guess, in rare circumstances, will charge a flat fee, but the fee will be much larger. So when the way my office operates is we have you sign a retainer. That's a retainer agreement or a engagement letter. That's the agreement between you and me, and it actually looks like a letter. Um, and it outlines what we're going to do for you. It's a binding contract. You're hiring me to do a certain work, so a certain job, right? So you're hiring me to represent you in a divorce in this particular court. So I'm not going to do immigration work. So there might be immigration problems because of the marriage, but for that, that's outside my expertise, and you'd need to go hire an immigration attorney to do that. There could be domestic violence or something like that, depending on how bad it is. There obviously might be criminal charges. I'm not a criminal lawyer, so you would need to have a criminal. So the retainer, um, the written document, the written contract, it should specify all of that. And for example, the hourly rates. My hourly rate is this, paralegal is this, the clerk is this, and that's just the legal fees. There will definitely be other costs that will be billed to you as they're incurred. I mean, filing fee to file it to file the document in the courthouse, a sheriff's fee to serve the other side. There could be court reporter fees if we go to the hearing. We want to have it transcribed. We want a record of the hearing. Many times the courts will require a court reporter, like in a custody trial, and that can get but those are outside third-party charges. I do not mark them up or anything. Um, then we expect you to pay money up front. So that would be like an initial deposit. We take that money and we put it into an escrow account. Now, the escrow account is separate. The lawyer has an escrow account and the lawyer has an operating account. So the escrow account is money that is held separate from from all of the other lawyers' business, personal business and law office business. And that money, the account is um, regulated by the state, and that's where you put the initial deposit of unearned fees. So in other words, when you first hire me, you give me a retainer amount, and then I deposit that into my escrow account. So, and at that point, I haven't done any work on your case. I mean, we're about to, of course, but at that moment, when that money goes into the escrow account, that money is yours. And then we start working on your case. And again, it's under the terms of the retainer agreement. So we will be working on a divorce and we will bill you for the divorce. We won't work on the immigration problem. We won't work on the criminal problem. And so as we do the work, we earn the money in the escrow account. So we'll transfer that money from the escrow account over into the law firm's operating account. And that's just what it says. I pay the people who work for me. I pay the rent, I pay the copy bills, and that kind of thing. So, um, whatever money is in the escrow account, belongs to the client. And so, but as the lawyer does the work, the lawyer is allowed to transfer that money out of the client's account, the escrow account, over into the over into the law firm, and that money is considered earned. So the situation arises many times when the escrow account goes down to zero. Well, we ask you to put more money in, and just be aware of that. That you might start off paying an escrow account of a few $1,000s, but that's just the start of your case. As it goes on, that money is transferred from the escrow account to the lawyer's account, and again, it's just going to go down and down and down, and it'll reach a point where we need to refill it. And if you don't or you can't, then we need to have a talk about how to proceed on your case. Um, then there's other things that are how to save money. It's just kind of practical advice. If you're going to have a meeting with your lawyer, prepare for it. Have written questions. Uh, you could even ask ahead of time. Ask the lawyer what is the meeting going to be about? What topics are we going to discover? What are we going to discuss? What topics are we going to discuss? What's next? Again, once you file, you're on the court's timeline. It's not up to the lawyer anymore. It's not up to the client anymore. It's not up to the other side. The court has a calendar and a clock that moves the case along. So what should we get ready for? What haven't we done yet? What do we need to do? What do we need to catch up on? Um, who do I need to talk to? Should I start lining up witnesses? Should I determine if they're going to be available on the trial date? Do we need to have this witness at all come to court? Are the documents good enough? Does the witness have to be there solely to get the documents in as evidence? What can you do to prevent that? Um, you want to update the lawyer on what's happened. So again, this case might be from when it's filed, it might be a year or even more. So things are going to happen. Um, did did the other side disappear? Do you know where they are? Do you know where your children are? What's the visitation been? Are they paying? Are they up to date on the uh, payments to you? Did they stop making payments on the mortgage on the house? Did your car get repossessed because you don't have money to pay the car note? So that's the kind of thing that you would want to have prepared ahead of time. Questions to and again with the Chat GPT or Claude AI or trying to think of these Meta and they I know Google just came out with one, and Copilot is the Microsoft. Ask them, you know, what should I ask my lawyer? And you'll get excellent questions. So something like that. So what happened in the past? What's going to happen? Um, what do I need to do? What do I need to know? What's my next step? In general. And again, the more organized you are, and hopefully the more organized the lawyer is, you're going to save. You're going to have a nice short meeting. 1, 2, 3, 4, 5, A, B, C, D. Done. Thank you. See you next week. Or it's going to be, um, a lot longer and a lot more disorganized. Um, whether it's family law or your family or someone else's family or a construction problem or car accident, always consider alternatives to court. And even when you're in court, consider other other possibilities to resolve it. Um, you'll save a lot of money and you'll save a lot of heartache, a lot of emotional. Even something like a car accident. Do you really want to face the person that ran into you, that injured you and damaged you, perhaps for life? Yeah. And, the same thing with maybe your spouse in a divorce. It would be if you have children, you'll have to see that person for a long time until the children are adults. But do you really want to be in a courtroom, where the decision is made by the judge? Would you rather have a resolution where there's back and forth and discussions and, again, think about it. Uh, some people want a trial. They just want the person to be judged. I mean, with which is going to be with a judge, obviously. So, but is that worth the money that you're going to pay? Is the candle worth the flame? So, I hope this has helped. Again, I'm Randall Borden, an attorney in Maryland and Virginia. This particular video has been for things other than the law. And I think a lot of it would apply to any dispute that you're in. And you have a emotional investment, and how much do you want to expend on your battles, and make an informed decision. So thank you very much. Goodbye.